Get your hands off that pump and get back in your car because women like you don't stop here." The fluorescent light above pump number 2 at the Edgewater Texaco had been flickering for 3 weeks and nobody had come to fix it. And on the night of October 14th, it buzzed and stuttered over the cracked concrete like something nervous, like something that already knew what was about to happen beneath it. Route 9 ran long and empty through Oak Ridge County, and the Edgewater Texaco sat at the only exit for 31 miles in either direction, which was the only reason Adeyeze Okafor had turned off the highway at all. She had been driving since 7 o'clock that evening, coming back from a 3-day judicial conference in the capital, and the needle on her fuel gauge had been sitting in the red for the last 40 minutes, while she told herself the next exit would have something, and the next one after that. Until finally, the Edgewater sign appeared out of the dark like a small and grudging mercy. She was 52 years old, and she was wearing what she always wore when she traveled alone and did not want to be looked at. Dark slacks, a plain gray jacket, her natural hair loose around her face because she had stopped pinning it back the moment the conference ended, and she was finally blessedly by herself. There was nothing about the way she looked standing at that pump that told any passing stranger anything about who she was or what she did or what rooms she had authority over. She was a tired black woman alone at a gas station late on a Wednesday night. That was all anyone could have known. The patrol car pulled in from the highway without its lights on. Officer Brett Calloway was the first one out. He was 6 feet 2 inches tall, built thick through the chest and shoulders, with close-cropped blonde hair and a jaw that sat forward like it was looking for something to push against. His badge caught the flicker of the broken light as he walked. He was 44 years old and had spent 11 of those years working Route 9, and he walked across the concrete with the specific, unhurried confidence of a man who had never in this county on this road at this hour been told that he was wrong about anything. Deputy Ryan Foss got out of the passenger side and stayed near the car. He was 29. His hands went into his belt and stayed there. Calloway did not slow down as he crossed toward pump number 2. His eyes moved over Adeze's car, a silver sedan, 4 years old, out of county plates, and then they moved over Adeze, and what settled in them was not suspicion exactly. It was something older and more comfortable than suspicion. It was the look of a man who had already decided. He stopped 6 feet away. He looked at her the way a person looks at something that has ended up in the wrong place. Then he said what he said. Adeze's hand tightened on the fuel nozzle. The pump clicked and hummed. The broken light buzzed overhead. Foss stood near the car and looked at the ground. She did not answer immediately because in the first second, she was simply parsing what she had heard, locating it, understanding its shape, and in the second she was measuring her options, and by the third second she had decided to be calm, because calm was the only thing that could not be used against her later. "I'm almost finished," she said. "I'll be gone in a minute." Calloway gave a short laugh that had nothing warm in it. "You don't get to decide that. Not here." The pump was at 63%. Adeyeze kept her eyes on the numbers, and her hand on the nozzle, and her voice at the same level. "I've been driving for 4 hours. This is the only station for miles in either direction. I don't have enough fuel to reach the next exit, which means if you send me back onto that highway right now, I'll be stranded on the shoulder of Route 9, somewhere between here and the county line. I'm asking for a few more minutes. That's all." "That's the problem," Calloway said. "You think you can stand here and negotiate. I'm not negotiating." She glanced at him then briefly. "I'm asking for basic courtesy." He took a step closer. Not a large step, but a deliberate one, the kind that was meant to be felt rather than measured. "You want courtesy," he said quietly. "Then you should have stayed in your part of the road." Foss shifted his weight behind the car. His right hand moved half an inch toward his radio and then stopped. "I haven't done anything wrong," Adeze said. "You people always say that." The phrase came out smoothed by repetition like a stone that had been handled so many times it had lost all its edges. Something tightened in her chest. Not fear, not quite, but the particular sensation of recognizing something she had hoped she would not have to recognize tonight. She knew what this was. She had known it in other forms, on other days, in other rooms where the rules changed depending on who you were, but knowing it did not make it smaller. "I'm a paying customer," she said carefully. "That's all that matters here." Calloway shook his head, a slow, dismissive motion, the way someone shakes their head at something beneath argument. "No," he said. "That's not how it works out here. Let's just Foss started from behind the car." "I've got it," Calloway said without turning. He took another step. He was close enough now that she could smell the coffee and the leather of his uniform, close enough that she had to resist the instinct to step back, because stepping back would give him something, and she was not going to give him anything she did not have to. "Let me see your ID," he said. She blinked. "I don't consent to that without cause. You haven't stated a cause." His eyes narrowed. The pump clicked behind her 78%. "I'll decide what constitutes cause," he said. "That's not how that works either." Something moved across his face then. Not anger yet, but the thing that comes just before anger. The compression that happens when a man who is not used to being answered back encounters a woman who keeps doing it without raising her voice or breaking eye contact or giving him anything at all to grab hold of. He was not accustomed to this. She could see that clearly. She could also see that it was making things worse. From her jacket pocket, the small leather card holder that held her judicial identification slipped free and fell silently without drama to the cracked concrete beside her left shoe. It lay there between them, unnoticed by Calloway, who was looking at her face and not at the ground. Adeze saw it fall. She did not reach for it. She did not mention it. Calloway's hand moved toward her arm. He grabbed her with his right hand, fingers closing around her forearm above the wrist, and the grip was not exploratory or hesitant. It was the grip of a man who had done this before and expected it to work the way it had always worked, which was completely and without consequence. The fuel nozzle slipped from her left hand. It swung on its hose, and gasoline splashed across the concrete, cold and sharp-smelling, darkening the cracked asphalt around her shoes. "Hey," she said at once, a single syllable, not a scream, but a statement clean and on the record. Foss took one step forward from behind the patrol car. He opened his mouth, then he stopped. His foot came back. His mouth closed. He stood there with his hands in his belt and looked at a point slightly to the left of what was happening, and that was the moment, though he would not understand it as such until much later when he chose the thing he was going to have to live with. "I am not resisting," Adeze said. Her voice was controlled, each word placed deliberately because she understood with the terrible lucidity that comes when the mind shifts into a particular kind of survival mode that she needed every detail of this to be clean. No raised hands, no sudden movements, no anything that could be reframed as resistance or aggression, or anything other than exactly what it was, which was a woman being handled by a man who had decided he could. Calloway pulled her off balance and turned her toward the hood of her car, and when she stumbled slightly on the uneven concrete, he used the stumble to press her down against the metal. The hood was warm from the engine warmth, soaking through the fabric of her jacket immediately, and she put both hands flat on the surface and felt the vibration of the cooling engine through her palms and the roughness of the seam at the edge of the hood beneath her fingertips. The fluorescent light buzzed. The highway was silent. "Stop resisting," Calloway said. "I'm not resisting." Her voice was steady. She needed her voice to be steady. "I'm not. Please. You're hurting my arm." Calloway tightened his grip briefly, a pressure that traveled up through the joint in a way that would leave a bruise she could feel for days afterward. And then he shifted her weight and brought her down from the hood to the ground, one knee on the concrete, then both her free hand catching herself on the cold, wet surface. She looked up. Calloway was standing over her with his thumbs in his belt, and his face had settled into something that was not anger anymore. Anger would have implied that she had done something to provoke it. What was on his face was simpler and more comfortable than anger. It was satisfaction. The specific satisfaction of a man who has restored what he believes is the correct order of things. Foss was looking at the highway. The concrete was cold under both her knees. She could feel the dampness from the gasoline that had spilled near the pump seeping through the fabric of her slacks. The broken fluorescent light kept buzzing overhead, that particular stuttering frequency that gets into the back of your teeth. She cataloged all of it, the cold, the light, the smell, the precise location of the pain in her forearm, the exact words he had used, and the order he had used them in, because she understood even now, kneeling on the concrete of the Edgewater Texaco at 11:47 p.m., that what she chose to do with this night was not yet determined. Calloway looked down at her for a long moment. Then he said the thing he said easily, the way people say things they have thought many times but never bothered to filter because they have never had reason to believe anyone would hold them accountable for it. People like you are all over this road thinking they got the same right to be here as everybody else, and it gets real old real fast out here in the dark where nobody's watching. He released her, roughly stepped back, adjusted his belt. "Get in your car," he said, "and get off my road." She stayed on the ground for a moment, not from weakness, from the deliberate, precise choice to let every second of it be exactly what it was, with no movement from her that could complicate the truth. Then she put one hand on the side of her car and stood. The bruise on her forearm was already beginning its dark work beneath the skin. Her knees were wet from the concrete. She reached for the fallen nozzle, finished fueling in silence, the numbers climbing on the display, while Calloway walked back to the patrol car without looking at her again. And when the pump clicked off, she replaced the nozzle in its holster and got in her car. She drove out of the Edgewater Texaco and back onto Route 9 and did not look in her rearview mirror. Calloway watched her taillights disappear. He said something to Foss. Foss nodded. Neither of them wrote anything down. Neither of them logged the stop. Neither of them turned on a body camera or picked up a radio or filed a single report about what had happened at pump number 2. They got in the car. They drove. This night, Calloway believed was over. Adeyeze got home at 2:18 in the morning. The house was the way she had left it, the lamp on in the front room because she always left it on when she drove back at night, the kitchen table still holding the coffee cup from that morning, and the stack of case files she had brought home to review over the weekend. She set her bag down near the door and stood in the hallway for a moment, and then she went to the kitchen and washed her hands at the sink, running the water, hot, working the gasoline smell out from under her nails, watching it spiral away. She dried her hands and stood there looking at the bruise. It had darkened quickly the way bruises do when they are serious, a deep purple blue already visible against her skin tender when she moved the joint, telling her in plain language what the next several mornings would feel like. She covered it with her sleeve. She sat down at the kitchen table because she could not sleep yet, and because there was a docket she had not fully reviewed for the morning's hearing, and because the habit of preparation was stronger in her than almost anything else. She opened the first file. She read the case summary. She read the list of named parties. She turned the page. Officer Brett Calloway. Officer Ryan Foss. She set the page down. She picked it up and read it again because the first time she had read it, she had not fully believed what her eyes were processing, and the second time confirmed it. The hearing set for 9 o'clock the following morning in her courtroom, the case she had been assigned 3 weeks ago, the misconduct matter she had reviewed and prepared for and accepted without any reason to expect anything unusual about it, was a civil rights action brought by 6 black motorists on Route 9, alleging that officers of the Oak Ridge County Sheriff's Department had been stopping them without cause, intimidating them, seizing cash without documentation, and burying every complaint before it could go anywhere. The primary named officer was Brett Calloway. His partner of record was Ryan Foss. She sat with that for a long time. The lamp in the front room made a small sound, a faint electrical tick she had heard 1,000 times before and never noticed. The case file sat open in front of her. The bruise under her sleeve ached. She did not call anyone. She did not contact the court administrator. She did not send an email to the chief judge's office or ask the clerk to reassign the matter or warn any of the attorneys about what had happened on Route 9. She thought about doing all of those things, and she understood why each one was the obvious and sensible choice, and she chose none of them. Because if she spoke now, if she disclosed now, Calloway would become a man who had made a terrible mistake with the wrong woman. The story would become about that, about her, about one night, about the irony of it. And the 6 people whose names were in that file, and the others whose names were not in any file because they had been too frightened or too exhausted or too certain that nothing would come of speaking up, they would be footnotes. The pattern would shrink back into the dark. She closed the file. She turned off the kitchen light. On the counter near the door where she had emptied her pockets when she came in, the small leather card holder sat. Calloway had stepped past it on the concrete. He had never picked it up. He had never opened it. He had never seen the name and title embossed on the identification inside. He did not know what he had put his hands on tonight. She was awake at 5:30, which was not unusual. Sleep had come in pieces, and she had stopped fighting it somewhere around 4 and simply lay still in the dark until the alarm made the decision for her. She moved through this morning deliberately without hurry, the way she always moved on the days when the courtroom would ask something serious of her. She made coffee and drank it standing at the kitchen window while the neighborhood came slowly into the early light. A neighbor walking a dog, a trash truck 2 blocks over, the ordinary movements of people who had slept without incident and were beginning a day they had no reason to fear. She chose her darkest robe, which was the one with the heaviest fabric, the one that moved with a certain weight when she walked. She pinned her hair back with the 3 pins she always used. She reviewed the docket one final time at the kitchen table, coffee gone, the case file open to the page with Calloway's name. The bruise on her forearm was darker this morning than it had been last night. She looked at it without expression. Then she pulled the sleeve of her robe down over it and moved on to the next thing. It would ache all day under that fabric. She knew that. She accepted it the way she accepted most things she could not change completely, and without spending energy on the acceptance itself. She drove to the courthouse alone on a route that took her briefly past the Route 9 turnoff, visible from the overpass, the Edgewater sign small and white in the morning distance. She did not slow down. The courthouse was already opening when she arrived. Staff greeted her in the hallways in the usual way. Nothing about her face gave anyone any reason to ask a follow-up question. This was a skill she had been developing since long before she had a robe or a bench or a title. The ability to carry something difficult inside an exterior that gave nothing away, not from suppression, but from the precise understanding that certain things needed to be kept intact and whole until the moment when they could be put to use. She thought briefly of the women whose names were in the file, Gloria Tate, Patrice Hollis, and the others. She thought of Marcus Webb, the truck driver who had written his account in careful block letters, as though he wanted to make sure every word would be legible. She thought of the woman who had not filed a report because she had been alone on the road with her children, and she had made the calculation that silence was the safer option. They did not have her robe. They did not have her bench. What they had as of 9 o'clock this morning was her courtroom. She intended to make that mean something. By 8:40, the courtroom was nearly full. The plaintiff's table was organized with the particular neatness of attorneys who had been working this case for a long time and were ready for it. Files arranged exhibits tagged a yellow legal pad in front of Nathan Reeves with handwritten notes in a column so straight they looked typeset. Reeves was 41, quietly built with the kind of face that did not advertise itself, which was part of why he was effective. He did not grandstand. He let the record do the talking, and he built records the way a mason builds walls, one stone at a time, carefully fitted, not going anywhere. The defense table told a different story. Brett Calloway arrived at 8:45 in his dress uniform, which was pressed sharply enough that the creases looked structural, as though they were holding him together. His blonde hair was neat. His badge caught the courtroom light the way it had caught the light at the Edgewater Texaco, though the quality of the light was entirely different. He carried a paper cup of coffee from the vending machine down the hall, and he sat with his back away from the table, leaning on one arm, with the posture of a man performing relaxation because he wanted the room to see it. County counsel sat beside him with a briefcase and the careful face of someone managing expectations. The union lawyer sat on Calloway's other side and had already put on his reading glasses and taken them off twice. Foss sat at the far end of the defense table, one seat removed from Calloway, not touching his own coffee. His back was straight, but not from confidence. It was the straightness of someone sitting very still so that nothing around them gets disturbed. Calloway talked. He talked in the way people talk when they want the room to hear that they are not worried, just below full volume directed at the county council and the union lawyer, but shaped for the gallery. He said the word smoke 3 times. He said that the complaints were the same old story, people making noise, filing paperwork, using words like discrimination, the way other people used weather as a conversation starter, and then it all disappeared because none of it could be proved. He said that by lunch this would be done and he would walk out clean. He said that no judge was going to sit up there and make an example of him over a bunch of unverifiable roadside claims from people who were already upset about being stopped. He said this last part, and then he tapped the rim of his coffee cup with one finger and looked around the room with the settled expression of a man who had been through hearings before and knew how they worked and was not afraid. Foss looked at the table. The county council gave Calloway a warning look and said nothing. The union lawyer had stopped pretending to review his notes. He was watching the side door, not because he expected anything particular from it, simply because experienced lawyers in uncertain situations develop the habit of watching exits. At 8:58, the bailiff called for order. The room stood. The side door opened. Calloway turned toward the bench in the automatic way people turn toward the bench when the bailiff calls the room to order, the reflex of a man who has been in enough courtrooms to know the choreography. And he was in the middle of raising his coffee cup for one last sip when he saw her. She was walking to the bench with her files under her arm and her dark robe moving with that particular weighted precision, and she had not yet looked up. And for one fraction of a second, Calloway saw only a black woman in a judicial robe and did not understand. And then she sat down and arranged her files and looked up, and something in the angle of her face or the set of her jaw, or simply the specific reality of her presence in that specific chair, reached across the courtroom and hit him like a door swinging open into a dark room. The coffee cup slipped from his hand. It hit the edge of the defense table and tipped, and the coffee, still hot enough to steam, spread in a slow, dark arc across the papers nearest his elbow, dripping off the edge in a thin, brown stream that reached the carpet without anyone moving to stop it. Calloway did not move. He sat with both hands flat on the table and his mouth slightly open, and his face doing something that it had probably not done in a very long time, going completely, utterly empty, like a screen between one image and the next. Foss turned at the sound of the cup hitting the table. He followed Calloway's gaze to the bench. His mouth opened. His shoulders went down in a single movement that looked less like surprise and more like a man receiving news he had somehow been dreading without knowing what the news would be. He sat very still with his mouth open and did not close it and did not speak, and looked for all the world like someone who had just watched the floor crack along a line they had been walking over for months. The gallery had not yet understood. The reporters in the back were writing something, probably the case number, the appearance of appearances. The civilian witnesses on the plaintiff's side were looking at their attorneys. Nathan Reeves was looking at a daïse with the quiet attention of a lawyer who had learned to read a room before speaking in it, and what he was reading now made him set his pen down very carefully on the yellow legal pad. At the bench, a daïse settled her files into their arrangement. The docket page on the left, the marked exhibits list on the right, the morning's first ruling already prepared. In the event the defense moved immediately for something procedural, which she expected they would. She had been in enough hearings to know that the first move of a defense caught off balance was to try to change the board. She looked up. Not at Calloway specifically, at the room. The long-practiced survey of a judge claiming a space, measuring its readiness, establishing by the direction and weight of her attention alone that the room now belonged to her in the particular sense that courtrooms belong to the person who sits above them. Then her eyes moved as they moved during every hearing to the defense table, and she looked at Brett Calloway. He was a man sitting in a puddle of his own spilled coffee, with his face the color of old paper, and his hands pressed flat on the table as though the table was the only solid thing left in his world. He was breathing, but only barely. He looked like someone who had reached for a door he had opened 1,000 times before, and found that this time it did not lead where he expected. Daese held his gaze for exactly as long as she held every witness's gaze during a preliminary survey of the room, which was long enough to register and not a second longer, and then she looked at Nathan Reeves and then at County Counsel and then at her clerk. "Be seated," she said. Chairs scraped. Papers shifted. Someone in the gallery cleared their throat. The bailiff moved back to his position. The court reporter found her rhythm. The ordinary machinery of a hearing reassembling itself around two men at the defense table who had not fully returned to their bodies yet. Calloway's hands moved from the table to his lap, where they sat in fists that he was clearly not aware he was making. His eyes returned to the bench again and again with the compulsive, uncontrolled quality of a man checking to see if something impossible is still impossible the second time he looks. It was. Daese opened the docket. "The court is in session in the matter of Tate et al. Versus Oak Ridge County and related parties," she said. "Counsel will note appearances for the record," and the hearing began. The clerk read the case number into the record, and the attorneys noted appearances, and the machinery moved forward in the way it always moved forward in the first minutes of a hearing. Steadily, formally, with the particular kind of procedural calm that exists precisely so that rooms full of frightened or angry people have something stable to stand on, while the larger things are sorted out. The county attorney rose before the first witness was called. "Your Honor, the defense would request a brief recess to deny Daese," said. The speed of it stopped him mid-sentence. He blinked. "Your Honor, I believe there may be a matter affecting—" "There is no matter before this court that prevents this hearing from proceeding as scheduled," Daese said, her voice, even her eyes, on the file. "Counsel may address the evidence and the law. We are not here to manage nerves." A few heads turned in the gallery. The union lawyer straightened in his chair with the adjusting motion of a man recalibrating. Calloway looked at the bench and then looked away, and then looked back, unable to stop the way you cannot stop looking at something that should not exist. Foss was staring at the table. He had been staring at the table since she sat down, and the quality of his attention fixed inward. The look of a man running calculations with no good answers coming back was beginning to attract glances from the gallery that he was too far inside his own head to notice. Daese folded her hands on the bench. "Call your first witness," she said. Nathan Reeves stood. He adjusted his jacket. He looked briefly at the defense table, not at Calloway's face, but at the general posture of the men there, the way a doctor looks at a patient before beginning an examination, assessing what he is working with and what it will take. He said calmly and clearly, "The plaintiff calls Officer Brett Calloway." Calloway did not move. The union lawyer leaned toward him and whispered. Calloway's jaw tightened, but he stayed in his chair for a half-second too long, long enough for the bailiff to take notice, long enough for two of the gallery's civilians to exchange a glance. Daese's voice came quiet and entirely without urgency. "Officer Calloway, you have been called." He stood. Reeves began at the beginning, which was always where the damage was deepest, because the beginning contained the numbers, and numbers had a way of sitting in a room long after the words around them had been argued over and qualified and explained away. "Officer Calloway, would you tell the court how long you have been assigned to Route 9 Corridor Patrol in Oak Ridge County? 11 years. And over the past 13 months, the period covered by the complaints before this court, how many discretionary stops did you conduct on Route 9 after sunset?" Calloway's answer came with a careful vagueness. "I'd have to consult departmental records for an exact figure." Reeves nodded as though he had expected nothing else. "Let me assist you. According to dispatch logs and patrol summaries already entered into preliminary evidence, you initiated 141 discretionary roadside stops on Route 9 over 13 months. Of those, 141.94 involved black drivers." He paused. Does that refresh your recollection? The union attorney objected. Reeves referenced the records. Adayez overruled the objection without adjusting her expression. Calloway said, "I don't decide stops based on race." Then on what basis do you decide suspicious behavior? Vehicle condition, failure to maintain lane, equipment violations. Reeves lifted a page from his table. In 38 of those 141 stops, no citation was issued. No formal warning, no arrest, no record in the file of any kind except officer contact. He let that settle. Would you like to explain why so many drivers were pulled over and released without any formal action? Officer discretion, Calloway said. Reeves repeated the phrase with the careful neutrality of someone placing a piece of evidence on a table. Officer discretion. Would you define that for the court? An officer makes judgment calls in the field about who appears to require attention. I see. Reeves turned a page. Over those same 13 months, how many times did your body camera fail to activate during a stop involving a black driver? Equipment issues happen. They do. Reeves reached for a bound document. Your Honor, I'd like to mark as Exhibit 12 an internal maintenance summary for Officer Calloway's assigned body camera unit covering a period of 7 months. Officer Calloway, I'll ask you to read the highlighted notation on page 3. The document was passed. Calloway looked at it. His eyes moved down the page. Device inspected. No hardware fault found. Page 5, please. Calloway's jaw tightened. Reported failure inconsistent with bench testing. And page 7, unit functioning within normal parameters. Reeves retrieved the document. So the camera worked, Calloway said most of the time. Most of the time, Reeves repeated. And yet it repeatedly failed during stops involving black motorists who later described cash being taken. Let's talk about those stops. He returned to his table and lifted a thin spiral notebook sealed in a clear evidence sleeve. Officer Calloway, is this your patrol notebook? Calloway looked at it. Yes. Would you please read the notation on the page marked with the yellow tab? Calloway looked at the page for a moment longer than reading required. Then settled roadside. What does that mean? It could mean a verbal warning was handled in the field. Reeves's voice did not change in volume or tempo, but something in it sharpened by a single degree. A verbal warning is logged as a verbal warning. A written warning is logged as a written warning. Settled roadside is not Oak Ridge County Sheriff's Department terminology. So I'll ask again, what does it mean? Calloway looked at the bench. Adayez was writing something on the page in front of her, not looking at him, which somehow made it worse, the sense of being observed by someone who did not need to watch in order to see. It means the issue was resolved in the field, Calloway said. And how was it resolved? No answer. The silence held in the room long enough for the court reporter's fingers to stop moving on her keys, waiting. Adayez said without looking up. The witness will answer the question. It was handled, Calloway said. Reeves placed the notebook back on his table. The driver of the vehicle corresponding to that notation submitted an affidavit stating that you told him a tow truck would cost more than what he had in his wallet. Suggested that his son in the back seat could be taken into temporary custody if the stop escalated to an arrest, and then accepted $650 in cash, which you described as, and I'm quoting from his sworn statement, settling the inconvenience right here. Was he lying? Calloway's voice had lost its morning confidence. I don't recall that stop specifically. Reeves tilted his head. Strange. You recalled enough to write it down. At the defense table, Foss looked up for the first time in several minutes. Something in his expression had changed. The stiffness had shifted into something more complicated. Something that sat between relief that he was not in the witness chair yet, and dread about what it would feel like when he was. County counsel had stopped writing notes. The union lawyer was watching Calloway the way a person watches someone walking a ledge, not sure whether to call out or stay silent. Adayez lifted her eyes briefly from her notes and looked at Calloway in the witness chair. The way she looked at all witnesses, which was fully and without charity, but also without malice, the look of someone whose job was to see exactly what was there, and not one thing more or less. She looked back down. "Proceed, counsel," she said. Reeves worked through the complaints in order, and the order mattered because each one built on the one before it, the way floors build on foundations, not dramatic, not showy, just load-bearing. Complaint 1. A retired school custodian from Macon stopped on a Thursday evening threatened with impoundment, $480 taken with no receipt and no report. Calloway denied it. Reeves noted the denial for the record without commentary and moved on. Complaint 2. A nursing assistant traveling home after a night shift told that things go smoother for people who know how to cooperate. $310 taken from her center console after Calloway suggested the bills might be connected to something. No drugs found, no seizure form filed. Calloway denied it. Reeves nodded slowly and moved on. Complaint 3. A pastor driving back from a hospital visit told his car could be held for inspection unless he wanted to take care of it. Now $550 taken, no paperwork of any kind. Calloway denied it. The union lawyer started to write something on his legal pad and then stopped. By complaint. 4. The room had begun to understand what it was looking at. Not 6 individual stories, but one story told 6 times in 6 different voices, and the voices were all describing the same geography of intimidation, the implied threat, the suggestion that children or cars or freedom might be at risk, the cash appearing to make the problem disappear, and the silence afterward that was enforced not by any single dramatic act of suppression, but simply by the certainty that no one would be believed. Officer Calloway Reeves said after the 6th denial had joined the others in the record, "You are under oath." Calloway looked at him. "I know that." "Good. I want to make sure because I'm going to show you one more piece of your own handwriting." He lifted a second marked page from the notebook. "This notation corresponds to a date 8 months ago. I'd like you to read it for the record." Calloway took the page. He looked at it. The room was very quiet. "Read it, please," Adayeze said. Calloway's mouth tightened. Single mother. Scared. Paid quick. Nobody moved. Reeves waited several seconds before asking his next question because several seconds was what that phrase needed. What does paid quick mean? It could refer to a fine paid in the field. Fines are documented. Fines are receipted. Fines have case numbers. Reeves stepped back from the witness stand, not dramatically but deliberately creating distance between himself and the document. The way you create distance from something you want the room to look at without your presence in the way. So I'll ask you again. What does paid quick mean? Calloway looked toward the defense table. The union lawyer gave him nothing. County counsel had his hands clasped on the table and was looking at a fixed point on the wall above Reeves's head. "I don't remember the specific stop," Calloway said. "Of course." Reeves turned a page. "Let's discuss your body camera policy. Your department's General Order 11C requires activation at the moment of initial contact with any civilian during an investigative encounter." Correct. "And that policy does not allow for delayed activation." "No. Does it allow an officer to decide not to activate the camera because the encounter might be, let's say, difficult to explain afterward? No. And yet in 7 of the 12 stops corresponding to civilian complaints before this court, your camera was either not activated, partially obstructed, or listed in your report as having malfunctioned." Reeves produced the maintenance summary again. "We've already established that the camera worked, which means the decision not to use it was not the camera's decision. The objection from the defense came, but it came slowly, like something tired. Adayeze overruled it. Reeves moved to the center of the room. "Officer Calloway, would you agree that a law enforcement officer who consistently fails to document encounters with black civilians, consistently accepts undocumented cash during those encounters, and consistently faces no internal consequences for either of those things, is operating within a structure that has been designed, whether intentionally or through years of neglect, to protect that behavior. The defense objection this time was faster. Relevance form compound question. Adaez considered it. Sustained as to form. Rephrase counsel. Reeves did not miss a beat. Officer Calloway, who reviewed your patrol reports over the past 13 months. My shift supervisor, Lieutenant Hadley, and when 6 complaints were filed against you over that same period, who reviewed them, Lieutenant Hadley, the same person. Reeves set his papers down. And how many of those 6 complaints resulted in any disciplinary action against you? Calloway looked at the bench. He looked back at Reeves. None. Reeves let the word finish its work. Then he said quietly, "No further questions on this point. The plaintiff reserves the right to return to this area of inquiry." He looked at Adaeze. At this time, the plaintiff would like to ask Officer Calloway about the events of last night. The defense attorney rose so fast his chair scraped. Objection. Relevance. This proceeding concerns the documented complaints before the court. Not overruled, Adaez said. The attorney sat down. The room had shifted again, not with noise, but with the particular charged stillness of people who understand that something they have been moving toward is now very close. Reeves approached the witness stand without any documents in his hand. This was a choice, and Calloway registered it. The absence of paper meant Reeves was working from something other than evidence already filed, and that meant something new was coming. And the realization crossed Calloway's face in the specific way that unwelcome realizations cross the faces of people who have stopped believing they could be surprised. Officer Calloway. Were you on duty last night after 11 p.m.? Yes. Were you working the Route 9 corridor? Yes. Did you at any point during your shift last night approach a civilian at the Edgewater Texaco station? A pause. Not long. But there. I encountered someone. Was that encounter logged in your patrol record? No. Was your body camera activated during that encounter? Calloway looked at the bench. Adaez was reading something, or appeared to be. No. Why not? Another pause longer. I didn't activate it. Reeves nodded once. Was the person you approached black? The silence that followed lasted 4 full seconds. 4 seconds is a very long time in a courtroom when everyone in the room is counting. Yes, Calloway said. The room did not erupt. It did something quieter than erupting. It shifted the way a building shifts when a structural thing changes somewhere inside it. Not dramatically, not visibly from the outside, but in a way that everyone standing inside it feels in the soles of their feet. The reporters in the back had stopped taking intermittent notes and were now writing continuously. The civilian witnesses at the plaintiff's table were very still looking at Reeves, not at the bench. Gloria Tate, seated in the second row behind the plaintiff's table, had her hands folded in her lap and her eyes forward, and she did not move. Reeves returned to his table. No further questions on this point. The plaintiff reserves the right to recall this witness. He sat. Adaeze's voice came from the bench, measured and clear. Officer Calloway, step down. You remain available for recall. Do not leave this courthouse. Calloway descended from the witness stand. He moved with the stiffness of a man managing something large and unwieldy inside his body, not falling apart, not entirely, but carrying the effort of not falling apart in every careful step. He returned to the defense table and sat, and he did not look at Foss, and Foss did not look at him, and the two of them sat 6 inches apart at the same table, and the space between them had become something that had weight and edges. The union attorney leaned toward Calloway and spoke close to his ear, something long and urgent, but Calloway was not listening in any meaningful way. He was looking at the bench again. He looked at it with the expression of a man looking at something he has been trying to stop looking at for the last 40 minutes, and cannot. Adaeze did not look at him. Reeves stood. The plaintiff calls Officer Ryan Foss. Foss's head came up. He was sitting at the far end of the defense table, and everyone who had been watching him for the last hour had been watching a man who had been getting progressively stiller the way objects get still when they are about to tip over. He had a legal pad in front of him with nothing written on it. He had been holding a pen for the last 30 minutes without using it. He looked at his new attorney, a younger man not affiliated with the union who had arrived during the recess and taken a seat one removed from the defense table, and the attorney gave him a small, grave nod. Foss set the pen down. He stood. As he moved toward the witness stand, Calloway turned to watch him. The look on Calloway's face was not the look of a partner wishing his colleague well. It was the look of a man sending a warning compressed into an expression, a narrow, still, specific communication that said, "We both know what you are not going to say." It was the look of someone who had spent 11 years deciding what other people were going to do in situations like this and had never been wrong about it yet. Foss saw it. His step slowed for a fraction of a second. Then he kept walking. Adayeze saw him see it. She noted it the way she noted everything in her courtroom, without expression, without reaction, but completely. She looked back at the file. Foss raised his right hand and took the oath in a voice that was almost steady. He sat with both palms pressed flat against his thighs, the way people sit when they are trying to keep their hands from doing anything observable. Reeves gave him a moment to settle, which was not a courtesy exactly, but a strategy. The kind of space that makes people feel the need to fill it. Then, Officer Foss, how long have you been with the Oak Ridge County Sheriff's Department? 3 years. And how long were you partnered with Officer Calloway? 14 months. During those 14 months, were you regularly assigned together to the Route 9 night corridor? Yes. Was Officer Calloway the senior officer in that partnership? Foss looked at his hands. Yes. Did he set the tone for how stops were handled? The defense objected on form. Reeves rephrased. Adayeze allowed the rephrased version. Foss answered. He decided which cars to stop, how long to hold people, how hard to push. When you say push, what do you mean by that? Foss breathed in through his nose. Pressure. Extended questioning. Suggestions that things could get worse if somebody didn't cooperate. Suggestions of what specifically? Towing. Arrest. If there were kids in the car, sometimes he'd mention child services. Once he brought up immigration with a driver who had Alabama plates and military decals on the back window. A stir moved through the gallery. One of the women seated behind the plaintiff's counsel pressed her hand over her mouth. Reeves let the moment exist before he moved on. Were those threats based on actual legal grounds? Foss looked at the table. No. Did you witness Officer Calloway request or accept money from motorists during roadside stops? The pause before this answer was not long, but it was the kind of pause that a room full of people notices and does not forget. Foss closed his eyes for one brief second. Not dramatically, just a man stepping off an edge he had been standing at the edge of for a very long time, and then opened them. Yes, he said. How many times? More than I counted. More than 5. Yes, more than 10. A longer pause. Foss looked at Reeves. Yes. At the defense table, Calloway muttered something short and vicious under his breath. The union lawyer's hand went to his sleeve, immediately pressing down. But the room had heard the tone, if not the words, and Foss had heard it too, and the way his jaw tightened told the court everything it needed to know about the pressure he was sitting inside right now. Tell me how it worked, Reeves said. Foss looked at a point above Reeves' shoulder, the specific focus of someone organizing thoughts into the order they need to be in. It usually started with something minor. Tail light out, drifting between lanes. Something small enough that it might not hold up if anyone looked closely. Calloway would approach the car and start talking. He had a way of doing it. He'd make the person feel like the situation could go in a lot of different directions, and most of them were worse than where they were currently standing. He'd use the word easy a lot. We can do this the easy way. He'd bring up the tow truck before anyone had mentioned towing. He'd suggest that whatever was in the car might attract additional attention if they stayed on the shoulder long enough, and the money Foss's hands pressed harder against his thighs. He'd say that a tow truck was going to run them more than what they had in their wallet. Or he'd say that roadside resolutions were sometimes available for people who didn't want the night to get longer than it needed to be. He never used the same phrasing twice, but it always meant the same thing. The cash makes this go away. And did it? Yes. Did you receive a portion of that cash? The answer came quietly enough that the court reporter asked him to repeat it. Yes. How? Sometimes cash, directly. Sometimes he'd cover something for me, a bill a meal. He said he'd look after me if I kept my head down. And did you? Foss looked at the table for a moment. When he looked up, something had changed in his face. Not performance, not theater, just the specific exhaustion of a man who has been carrying a particular weight long enough that he has forgotten what it was like not to carry it and is now for the first time putting it down. Yes, he said. I kept my head down. I told myself I was the junior man I was just riding along. Then I told myself I was already too close to get out clean. And then, after a while, I stopped telling myself anything honest. Reeves said, "Did Officer Calloway instruct you to leave your body camera off during stops?" Foss looked at the defense table. Calloway was staring at him with a look that had a specific direction and force to it. The concentrated physical pressure of a man trying to communicate through eye contact alone that certain things were not going to happen in this room today. Adese's voice came from the bench. Officer Foss. You will answer the question and you will direct your attention to counsel. Foss turned back to Reeves. He said his exact words were, "Keep the cam cold till we know what kind of people we got." Calloway was halfway out of his chair before the sentence finished. The sound he made was not a word, it was the sound of a man's composure breaking along a fault line that had been under pressure for 11 years. Adese's gavel came down once. Not hard. It did not need to be hard. Officer Calloway. Each word separate, weighted absolutely clear. You will remain seated. You will not interrupt testimony in this courtroom. Is that understood? Calloway stood for one more second with his chest rising and falling and his hands on the table, and then he sat. The room was very quiet. I asked you a question, Officer Calloway. Yes, Your Honor, he said. The words came out rough, like something dragged across gravel. Good. Reeves turned back to Foss. Last night. Were you with Officer Calloway at the Edgewater Texaco station on Route 9? Foss went still in a different way now. Not the stiffness of managed presentation, but the total stillness of a man arriving at the moment he has been moving toward since he got out of bed that morning. Yes. Did you witness an encounter between Officer Calloway and a black woman there? Yes. What happened? Foss's voice did not break, but it moved to a different register, lower, slower stripped of anything that was not the plain delivery of what he had seen. She was at the pump. She looked tired. She said she'd been driving for hours and needed the fuel to get home. He told her to leave. She said she was almost done. He told her that wasn't her decision to make. She said she was a paying customer. He demanded her ID. She declined without cause. He grabbed her arm and put her on the ground next to her car. Did she threaten either of you? No. Did she commit any crime? No. Did she resist? Foss's voice dropped further. She kept saying she wasn't resisting. She kept asking him to stop. The room absorbed that. Reeves waited a beat. Then Officer Foss, do you see that woman in this courtroom today? Foss did not look at the gallery. He did not look at the plaintiff's table. His eyes went with the same inevitability with which water finds a low place to the bench. His face changed, not dramatically, not with any theatrical collapse, just the way a face changes when a person finally stops holding something up. Yes, he said. Please identify her for the record. He tried once, and the sound that came out was not a word. He steadied himself. On his second attempt, she's the judge, he said. Judge Adayeze Okafor. The courtroom did not erupt. What happened was quieter than eruption and more permanent. It was understanding, the particular total irreversible understanding that moves through a room when something that has been circling the center finally lands there. The reporters were writing without pause. The civilian witnesses on the plaintiff's side were still the kind of stillness that follows arrival rather than anticipation. County counsel sat back in his chair as if a string had been cut somewhere in the middle of his back. At the defense table, Brett Calloway looked like a man watching the walls of something he had lived inside for a very long time come down all at once. "This court will take a 10-minute recess," Adeyeze said, and the gavel came down, and she rose and walked through the side door with the same measured step she had used all morning, and the door closed behind her. Imani Reese, her clerk, was already in the chamber with a file and a face that had gone quiet in the way faces go quiet when they are processing something too large for immediate expression. She was 27 years old and had been in this job for 8 months, and had spent this morning seated at her small desk beside the bench watching. She set the file on the corner of the conference table and looked at Adeyeze. "That was you," she said. It was not a question. "Yes," Adeyeze said. Imani pressed her lips together. "Then, do you need security? Not unless someone gives you a reason to call it." Imani nodded slowly, absorbing that. Through the chamber door, hurried footsteps passed in the hallway, the union attorney, probably, or county counsel, moving toward a phone. The sounds of a building that has just discovered it is in a different situation than it thought it was. "The defense has already asked the bailiff about filing an emergency recusal motion," Imani said. "I expected that." Adeyeze crossed to the small credenza by the window and poured herself a glass of water and drank half of it standing. She had not eaten anything since 5:30 that morning. The bruise under her sleeve ached with a steady informative pain that she had been noting and setting aside for the past 3 hours. She called Chief Judge Howard Parrish from the chamber phone. He was 71 years old and had been running the regional bench for 16 of them, and had heard enough things in those 16 years to have stopped being surprised by the capacity of people to fail each other in inventive ways. "I've been watching the transcript as it comes through," he said, which meant he had been reading in real time, which meant he had already understood before she called. "Then I'll be brief," she said. "If this is reassigned now, the story becomes about me, and one night on a back road, and the pattern becomes the footnote. That is not what the record says it is." Parrish was quiet for a moment. She could hear the faint sound of ice in a glass. He kept tea at his desk in the afternoons, even at 10 in the morning, which had always struck her as either eccentricity or optimism. And if you stay on it, then the pattern is the story, which is what it has always been. Another pause. When he spoke again, something in his voice had shifted from administrative to something older and less careful. "I will not let cowards use ethics as a shield for their own panic," he said. "Handle your courtroom." When she hung up, the 10 minutes were nearly gone. Imani had set a fresh copy of the morning's exhibit list on the conference table and was waiting near the door with the expression of someone trying to be useful without intruding. Adeyeze took her water. Finished it, set the glass down. She straightened the robe across her shoulders. "The motion will be denied," she said. "I know," said Imani. Adeyeze walked back to the door. Then she stopped, without turning. "The women on that road at night, they didn't have my robe. They had their word." Imani said nothing. There was nothing to say to that. Adeyeze opened the door and returned to the bench. The union attorney was on his feet before Adeyeze had fully settled into her seat. "Your Honor," he said, with the controlled urgency of a man who has spent the recess rehearsing the defense moves for immediate recusal of the presiding judge. "In light of testimony elicited in this hearing, it has become apparent that the court has a personal and direct connection to events that overlap with the subject matter of these proceedings, creating a conflict that we submit cannot be reconciled with the requirements of due process or judicial impartiality." He sat down quickly, as though proximity to his own argument had become uncomfortable. Reeves stood. He did not raise his voice, and he did not perform outrage because he did not need to. "Your Honor," The defense is entitled to seek whatever relief it believes is available. However, the record is clear on several points. This hearing began as an evidentiary matter concerning a documented and extensive pattern of extortion, racial targeting, and abuse of authority on Route 9, a pattern that predates the court's involvement by more than a year. The witness testimony identifying the bench as one of the affected individuals did not create that pattern. It confirmed it. The court has not testified. The court has not introduced facts outside the record. The court has ruled consistently and on the evidence before it. The defense's sudden interest in procedural impartiality appears to have materialized at the precise moment that its own witness placed the judge among the victims, which is not a conflict of interest. It is a consequence of having targeted someone whose position makes that targeting visible. The union attorney started to respond. Adeze raised one hand and the room obeyed before he had finished his first word. "The motion to recuse is denied," she said. "This court has not offered testimony, has not introduced extrinsic evidence, and has ruled on the admissibility and relevance of sworn statements properly before it. Should the court's personal involvement at any future point directly impair the ability to adjudicate fairly, that question may be revisited at that time. It does not impair it now." She looked at the defense table. "You have your ruling. Call your next witness, Mr. Reeves." The union lawyer sat. Calloway stared at the table, and the hearing continued. The second row behind the plaintiff's table had held Gloria Tate through the entire morning, through the stop statistics and the notebook notations and Foss's account of what happened at the Edgewater Texaco, and she had sat through all of it with her handbag held in both hands and her back straight and her eyes forward, the posture of a woman who had learned long before this morning to be very still in rooms where power was seated high. She was 71 years old. She had raised 4 children in Oak Ridge County, buried a husband, served on the deacon board at First Baptist for 22 years, and taught Sunday school to children whose names she still remembered. She wore a church hat the color of deep plum and a cream blouse with a small pearl button at the collar. When Nathan Reeves called her name, she rose without hurry and walked to the stand with the precise, measured dignity of someone who has decided to be unafraid and is honoring that decision with every step. She took the oath in a clear voice. She sat. She folded her hands. Reeves approached with a gentle diversion of his usual tone. "Mrs. Tate, would you tell the court where you live in Delaney, about 12 miles south on Route 9? And last March, on a Thursday evening, were you driving north on Route 9 with your grandson?" "Yes, sir. We were coming back from my granddaughter's birthday party in Caldwell. My grandson had just turned 8. He fell asleep in the back seat maybe 20 minutes after we got on the highway." She paused. "I remember being glad he was sleeping because I thought it would be easier." "What happened?" Gloria looked at Reeves steadily. "I was pulled over just past mile marker 43. Officer Calloway came to my window. No explanation for why he'd stopped me, just asked if I knew how long my registration renewal had been overdue. I told him my registration wasn't overdue. I'd renewed it in January. It was right there in my glove compartment. He asked me to step out of the car." "Did you?" "Yes. I wasn't going to argue with a man standing outside my car door in the dark." "What happened next?" "He walked me around to the back of the car. The other officer, the younger one, stayed near the hood. Calloway told me there were some questions about whether the car was legally mine, said he'd seen cases where people drove cars registered to other people, and it turned into a serious situation. He said it could go a lot of ways from here, and that some of those ways were a lot more inconvenient than others." "Did you understand what he was suggesting?" Gloria tilted her head very slightly. "I've lived 71 years, Mr. Reeves. I understood what he was suggesting. Did he ask for money?" "He said the paperwork for impoundment would cost more than most people had in their wallet, and that there were sometimes ways to handle things right there that saved everybody a long night." She paused. "He said $500. A murmur moved through the gallery. Reeves let it settle. "Did you have $500? "I had $220 in an envelope in my purse. It was grocery money for the week and my blood pressure prescription, which I pick up every 2 weeks. What happened to it? Gloria did not look down. She did not look away from Reeves. He took it, she said. All of it. At the defense table, Calloway sat with his eyes on the wood grain in front of him and his jaw set and his hands in his lap, and he did not look up. No receipt, Reeves asked. No receipt. No citation. No citation. No charge of any kind, no charge. He told me to drive carefully and said the county appreciated my cooperation. Why did you give him the money, Mrs. Tate? For the first time since taking the stand, something moved in Gloria Tate's face. Not weakness, not grief, but the specific expression of someone revisiting a memory that still has the power to make them angry and choosing to let the anger be informative rather than consuming. My grandson woke up, she said. He sat up in the back seat and looked out the window and saw the patrol car and started crying because he didn't understand what was happening. And he was 8 years old, and it was dark on the side of a highway. And Officer Calloway looked at my grandson and said that things tend to get complicated when children are involved. She stopped. I handed him the envelope. The courtroom was completely silent. Reeves said quietly, "Thank you, Mrs. Tate." No further questions. The defense cross-examination was brief and did not go well. The county attorney tried to suggest that Gloria might have misunderstood a discussion about standard towing fees, and Gloria looked at him with the particular patience of a woman who has outlasted many things that thought they could outlast her, and said, "Young man, I've paid towing fees before. I've paid parking tickets, registration fines, inspection fees. They don't come in cash and they don't disappear into an officer's back pocket." Brief controlled laughter rose in the gallery and collapsed under Adeyez's look before it had fully formed. Gloria Tate stepped down from the stand and walked back to her seat in the second row and sat with both hands folded in her lap, and the plum hat did not move. Marcus Webb was 44 years old, a long-haul driver out of Birmingham with broad hands that had the permanent crease and callus of someone who spent 40 hours a week on a steering wheel. He had driven Route 9 twice a month for 6 years because it was the most direct route between his 2 regular freight stops, and he had been stopped on it 4 times in the past year and a half, which was 4 times more than he had ever been stopped on any other road in his career. He took the stand with the directness of a man who had been waiting to say something in a room where it would be written down, and he said it plainly, without drama, in the specific economical language of someone whose job had taught him to communicate clearly and get to the point. The night in question, a Tuesday in June, 1:30 in the morning, westbound on Route 9 after a delivery run. Calloway had pulled him over at an intersection where the speed limit dropped from 55 to 40. Marcus had been doing 43. He knew this because his GPS log recorded it, and he had printed the log and brought it with him, and it was now Exhibit 14 in the record. Calloway's approach, friendly at first, the particular kind of friendly that Marcus had learned to read correctly after the first time, because it was the friendliness of someone who was deciding how much you were worth and how hard they would need to push to get it. He asked Marcus about the freight he was carrying. He asked whether there was anything else in the cab. He suggested that a vehicle this size coming through after midnight attracted a certain kind of official interest, and that a thorough inspection could take several hours. Then he said that certain situations had roadside resolutions for drivers who didn't want to lose a whole night to paperwork. "How much did he ask for?" Reeves said. "He said 900 would make it go away," Marcus said. "He said it like he was doing me a favor. Did you pay it?" Marcus looked at Reeves with an expression that was not resignation, but something more complex, the look of a man who has made a calculation under duress that he has been angry about ever since. "I had a delivery at 6 a.m. If I didn't make that delivery, I lost the contract. I had 3 kids at home. I paid it. Did he give you any documentation?" "Nothing." "Did he arrest you?" "No." "Did he cite you for the speed?" "No." "What did he say when it was over?" Marcus's jaw moved once. He said to drive safe and have a good night. Reeves paused. "Mr. Webb did." "Officer Calloway say anything during that stop that you've heard described again today in any other witness's account?" Marcus nodded. He used the same phrase, roadside resolution. And when I didn't say anything, he said, same as what that woman said in the first complaint, we can do this the easy way. The defense cross-examination produced nothing useful. Marcus Webb was not confused, not emotional in any way that could be leveraged, and not susceptible to the suggestion that he might have misunderstood a conversation conducted in plain English on the shoulder of a highway. After Marcus Reeves called Patrice Hollis, a home health aide from Milltown Compact and determined who had been stopped on Route 9 8 months ago with her nursing bag visible in the back seat, and had been told by Calloway that the county has people who look into situations like this, when she declined to hand over the $300 he asked for. She gave him $160, which was all she had. She had not filed a report, she said, because she did not believe anything would come of it. 3 witnesses, different backgrounds, different amounts, different months, but each one describing the same shape of encounter, the same language, the same implied threats, the same cash leaving hands without receipt or record or consequence. Not coincidence. Architecture. Sandra Cho had worked as a dispatcher for the Oak Ridge County Sheriff's Department for 9 years, and she had resigned 3 weeks ago, and she arrived in the courtroom carrying a sealed records envelope with both hands and the composed face of someone who had made a decision that cost her something and was not going back on it. She was 38, Korean American, with the careful stillness of a person who had spent years in a job that required her to hear things clearly and respond to them quickly and keep her own opinions entirely to herself. She sat in the witness chair with the envelope on her lap and did not look toward the defense table. Reeves established her credentials, 9 years dispatch log access, daily exposure to field officer activity reports, and then went directly to the matter. Miss Cho, in the course of your work, did you observe anything unusual about Officer Calloway's stop patterns? Yes. What did you observe? He ran vehicle plate checks on black drivers before he initiated any formal stop entry, sometimes 10 minutes earlier, sometimes 15 or 20, occasionally longer. Is that procedure unusual? It can be normal if an officer has observed a clear traffic infraction and wants to gather information before initiating a stop. But in Officer Calloway's case, there was frequently no corresponding violation entered at the time of the plate check. Just the registered owner's information, and then a stop, usually after dark. And what did the plate check typically show in terms of the registered owner? Name, address, sometimes previous contacts, enough to assess whether the driver was likely to be from the area, whether they'd had prior encounters, whether they were... She paused. Whether they were the kind of person who would know what to do if something went wrong. Did you notice a racial pattern in which drivers received these pre-stop plate checks? Yes. The majority were black drivers. You could tell from prior contacts' home addresses, or simply from how Officer Calloway logged the check in the notes field. After enough nights, it stopped looking like coincidence. Did you ever report your concerns internally? Yes. First to my shift supervisor verbally, then in writing to Lieutenant Hadley. And what happened? Nothing. Sandra said. Nothing happened. Reeves approached with a document. Miss Cho, I'd like to direct your attention to the dispatch log for August 9th of this year. Can you read the highlighted entry? She opened the envelope and found the page. Plate check at 8:42 p.m. Registered owner Gloria Tate. Stop not formally entered until 9:03 p.m. Stated cause at time of plate check none logged. Thank you. Now the entry for October 14th. Sandra found the page. Something in her posture changed, not visibly to most of the room, but visible to Adaeze, who was watching. It was the specific change that happens when a person arrives at the part of a document they have been dreading. Sandra read slowly. Plate scan request at 11:16 p.m. Silver sedan partial registration match. No stop ever formally entered. No stop logged at all. No stop logged, Sandra said. No contact entered. No outcome noted. Would that be unusual if a stop did in fact occur? Yes. If an officer initiates any contact, asks for identification, detains someone, uses any kind of force, it's supposed to be in the record, especially with a second unit present, Reeves said, and if it isn't in the record. Sandra looked briefly toward the defense table, not at Calloway somewhere above him, somewhere between the table and the back wall. If it isn't in the record, she said, then someone decided they didn't want a record. Reeves asked his next question carefully. Did Officer Calloway ever speak in ways that suggested certain drivers were easier targets than others? The defense objected. Adiese permitted the question only as it pertained to statements Sandra had directly heard. Yes, Sandra said. He had a phrase he used in the dispatch room. He called certain stops night money. He said drivers with out-of-county plates who were coming through after dark were less likely to fight back. He said... She paused. He said black drivers especially didn't want trouble in Oak Ridge after midnight. No one in the room moved. Reeves said, Did he say that in the dispatch room, within earshot of other staff? Yes. And no action was taken, no. The defense cross-examination was brief and did not recover its footing. The county attorney attempted to establish that Sandra had resigned under stress and might be carrying a grievance that colored her account. Sandra looked at him and said plainly, I was ashamed of what I was part of. That's not a grievance, that's a conscience. The cross-examination ended. Reeves remained standing after the county attorney sat. He looked at Adiese. Your Honor, in light of Miss Cho's testimony, the plaintiff requests that the dispatch log entries she's authenticated, including the entry for October 14th, be formally admitted into evidence. Additionally, the plaintiff notes that the entry for October 14th corresponds directly to the unlogged encounter described in this hearing by both Officer Foss and Officer Calloway himself. The entries will be admitted, Adiese said. She did not look at Calloway when she said it. She did not need to. The records custodian for Oak Ridge County Sheriff's Department was a compact man in his 50s who had been in his position for 17 years and who understood from the moment he had been served with a subpoena 3 days ago that the documents he was being asked to authenticate were going to be a problem for a great many people who outranked him and who had made the decision privately without ceremony at his kitchen table the night before that this was not going to be his problem to absorb. He authenticated the summary chart cleanly and without difficulty, and it was admitted as Exhibit 19, and when it was projected on the screen at the front of the courtroom, it had the effect that well-organized evidence has when it arrives. After hours of testimony, it made everything that had been said aloud visible in a different way. 13 months of stops on Route 9 arranged in columns. Date, time, officer, driver identification available from dispatch, camera status, documentation filed, outcome, complaints cross-referenced. The pattern was not subtle. It was not something that required interpretation or inference. It was simply there in the kind of plain visual language that does not require legal training to read a block of stops clustering heavily in the late-night hours, a disproportionate concentration of black drivers, a column of camera failures that lined up with the complaint dates like a key fitting a lock. Stops with no citation, no warning, no formal outcome. Then weeks or months later, a complaint filed. Then nothing. No internal review notation, no disciplinary flag, no acknowledgement of any kind. The word that did not appear anywhere in the chart because it was not in any report was the word money. But the shape of everything around its absence told the same story that 6 witnesses had told from the stand, and Sandra Cho's dispatch logs confirmed, and Calloway's own handwriting had supplied in the margins of a patrol notebook. There was something being taken on Route 9 that was never written down, and it was being taken from the same kind of people in the same hours by the same officer with the same absence of record for 13 months. Some things do not need to be stated in order to be understood. Calloway had stopped pretending to review any documents on the table in front of him. He sat with his hands in his lap and looked at the chart on the screen with the expression of a man watching something he built be taken apart piece by piece in a well-lit room by people who know what tools to use. Reeves returned to his table after the chart had been on the screen for long enough. He looked at his notes, but briefly the gesture of a man consulting a list he has already memorized. "Your Honor," he said, "the plaintiff requests that Officer Calloway be recalled to the stand." Adaize looked at the defense table. The union lawyer's mouth opened slightly, then closed. He had been making objections all morning from a variety of angles, some procedurally sound, some not, and he had been overruled more often than sustained. And he had the look now of a man who has run through his ammunition and is beginning to understand that the battle was decided before the shooting started. Officer Calloway Adaize said, "Return to the stand." Calloway stood. Foss had been recalled before Calloway, and he came back to the witness stand with a different posture than the one he'd carried this morning. Something had settled in him during the recess, or perhaps had finally been put down, and the result was a man who moved without the management he'd been performing all morning. He sat. He folded his hands. He looked at Reeves and waited. "Reeves," said Officer Foss, "since your testimony this morning, have you been approached by anyone and asked to change or reconsider any part of what you said?" "Yes." "By whom?" "By Officer Calloway. Last night in a conference room downstairs. The investigators, who had been seated near the aisle since the morning's recess, both turned a page on their legal pads simultaneously." "What did he say to you?" Foss looked at the table for a moment, then back to Reeves. "He said if I stayed consistent with the previous story, the version where we hadn't done anything, it was still manageable. He said I owed him. He said that nobody was going to take the word of a nervous rookie over a decorated senior officer." He paused. "He said I'd lose everything and still not be believed." "And how did you respond?" "I didn't say anything. I left the room." At the defense table, the union lawyer put both hands on the table as if steadying himself against something physical. Calloway was very still. Reeves said, "Officer Foss, I want to give you the opportunity now to add to or correct anything you said this morning. Is there anything you'd like the record to contain that it doesn't currently contain?" Foss breathed in slowly. When he let it out, the quality of the room changed the way it changes when a person stops managing themselves and simply speaks from wherever they actually are. "Yes," he said. He looked at Reeves. "I didn't just witness what happened on Route 9. I made it possible. Not by designing it, I didn't design anything. But I kept my camera off when he told me to, and I watched people hand over money that they needed for rent and medicine and groceries, and I told myself I was the junior man and I was just following the lead of the senior officer." He stopped. "But that wasn't true after the first time. After the first time, I knew exactly what it was. I chose to keep telling myself the story because the other story, the true one, was harder to live with." Nobody moved. Reeves said nothing. The silence offered Foss the space to continue, and he took it. "Mrs. Tate's grandson was 8 years old," he said. "I stood on the other side of that car and I heard him crying and I didn't do anything." He looked down. "That's in the record now." He looked up. His eyes moved to the bench, not with calculation. There was nothing calculating left in his face, but with the simple directness of a man who has something left to say and is going to say it to the person it most needs to reach. What happened at that gas station on Route 9 last night was not the first time Officer Calloway targeted someone because he believed no one would protect them. It was just the first time he chose someone whose position made it impossible for the whole structure to keep looking the other way. He stopped. There was nothing theatrical in any of it. No trembling voice, no dramatic pause, just the plain, exhausted fact of something that had been true for 14 months finally entering the room where it could be put to use. Reeves said, "No further questions." Adaize looked at Foss for a long moment from the bench. Not with sympathy exactly, and not with judgment, with the careful attention of someone who is deciding what a thing is worth and what it costs, and whether the weight of it has been understood. She said, "The witness may step down." Foss stood. He did not return to the seat beside Calloway. He took the chair behind plaintiff's counsel alone with his new attorney beside him, and he sat with his shoulders folded slightly inward. the posture of a man who has done the one thing he should have done much earlier and has discovered that there is no relief in rightness when you have waited this long for it, only the quieter, more durable thing that comes after responsibility acknowledged and owned. Calloway did not watch him cross the room. He sat with his eyes on the table and his hands pressed together under it, and his face carrying something that was not quite anger anymore, and not quite fear. Something older and less familiar. Something that had not had much occasion to visit him in 11 years on Route 9, which was the specific discomfort of a man who has operated without consequence for so long that consequence itself has started to feel like a violation. Adese looked at him from the bench. She had known men like Brett Calloway for most of her professional life. Not always this specific shape, not always this road, but the essential thing was recognizable. A man who had learned that certain people could be treated as if their experience did not fully count, and who had been confirmed in that learning by 11 years of silence from every supervisor, every review process, every institution that had looked at his record and found it easier not to look more carefully. The confidence he'd walked in with this morning had not come from nowhere. It had been built for him slowly by a structure that had rewarded his behavior with protection and punished his victims with disbelief. That structure had failed this morning to do what it had always done, and Brett Calloway had no idea yet what that meant for everything that came after. She was about to show him. He walked to the witness stand the way he would have walked somewhere he had decided to get to faster than his legs wanted to carry him. Stiff controlled each step, a small act of will against the momentum of everything the morning had produced. He was sworn in again. He sat. Reeves stood in the center of the room with a single folder. "Officer Calloway, you testified under oath this morning that the complaints against you are false." "Yes." "You testified that you did not target black motorists." "That's correct." "You testified that cash was never taken from any driver on Route 9 without documentation, and that any notation in your patrol records of settled roadside referred to lawful field dispositions." "Yes." "We have since heard from Mrs. Gloria Tate, who described in specific detail, including the sum of money involved and the precise threat made concerning her grandson, an encounter with you on Route 9 last March." "Is she lying?" "She's mistaken. Mr. Marcus Webb, who provided GPS documentation placing him at the location he described, who told the court you used the exact phrase roadside resolution and the easy way, and who paid you $900 he then had to account for to his freight employer, is he lying?" "He misrepresented the encounter." "Ms. Patrice Hollis." "She misunderstood what I said." "Miss Sandra Cho, a 9-year employee of your own department who documented your pre-stop plate check patterns in the dispatch log and heard you describe black drivers as night money in the dispatch room." Calloway's jaw tightened. "She has a grievance against the department." Reeves opened the folder. "Officer Foss, your partner of 14 months who has described in detail how the stops worked, what you said, what you took, and what he was told to do with his camera. Is he lying?" A pause. He's covering himself. By confessing to his own participation, he's making a deal. Reeves nodded once, slowly. "So, your position under oath is that every witness who has testified against you in this courtroom has independently decided to fabricate or distort their account, and somehow without coordination they have all arrived at descriptions of encounters that share the same language, the same mechanism, the same amounts, and the same absence of documentation." Calloway said people talk. They get together before these things. "And did they also get together with your own handwriting?" Reeves produced the exhibit. "Let me read you something from your patrol notebook. This is a notation from 8 months ago. Single mother, scared, paid quick. And from 6 months ago, he turned a page, another notation, Blue Accord older, 2 passengers. Settled easy, $250. And a third from the week of March 14th of this year, which corresponds exactly with the date Mrs. Gloria Tate described, Route 9 late. Woman kid in back, 220. No trouble." The room received that in a silence so complete that the ventilation system above the gallery became audible. Reeves said, "Read that last notation aloud, please." "I'd like to review the document," Calloway said. Adaize said, "You've seen the document. Read the highlighted notation." Officer Calloway. His mouth tightened. His eyes went to the page. Route 9 late. Woman kid in back. 220. No trouble. Gloria Tate in the second row did not react visibly. She sat with her hands folded and her eyes forward, and the only sign that the words had landed was the deliberate and total stillness she held them inside. Reeves said, "What does no trouble mean?" Calloway looked at the bench. He looked back at Reeves. "It means the stop resolved without incident." "What kind of incident?" No answer. Officer Calloway, a woman with her grandchild in the back seat, handed over her grocery and prescription money on the shoulder of a dark highway. "You wrote, 'no trouble.' From whose perspective is that 'no trouble'?" The objection from the defense was immediate and poorly formed. Adaize overruled it without inflection. Calloway looked at the witness railing. "It means she didn't make a scene," he said, and the words came out with a viciousness that he had not fully intended and could not take back. And the moment they were in the air, everyone in the room understood something additional about Brett Calloway. Not just that he had done these things, but that he had done them without remorse, and that the remorse he was performing now was the remorse of a man caught, not a man changed. Reeves let the silence hold for several seconds. He did not look triumphant. He looked like a man who has arrived somewhere he has been walking toward for a long time and is simply noting the address. "Officer Calloway," he said, "I want to ask you about last night." Reeves approached the witness stand without documents. His hands were at his sides. This was the part of the morning he had been building toward since 8:59, and he had no interest in anything between himself and the record. Last night at the Edgewater Texaco station on Route 9. "The woman you approached, did she threaten you?" "No." "Did she make any movement suggesting she posed a danger to you or your partner?" "No." "Did she have a weapon of any kind?" "No." "Did she commit any crime in your presence?" Calloway looked at the bench. He looked back at Reeves. "No." "Did she run? Did she raise her voice? Did she resist in any physical way?" "No." "She was fueling her car." "Yes. She told you she'd been driving for hours and needed the fuel to get home safely." "Yes." "And you told her to leave." "I assessed the situation as—" "You told her to leave," Reeves said again, not loudly, but with a precision that made the repetition function as a correction rather than an interruption. On what lawful basis she was behaving in a manner that seemed inconsistent with how she was alone. It was late. A woman fueling her car alone at night. That was your basis, combined with other factors. What other factors? Calloway said. She was at a station that doesn't typically see the kind of traffic. That doesn't see what kind of traffic? The witness stopped. Something shifted in his face, a small involuntary compression around the eyes. The expression of a man who can hear what he is about to say before he says it, and knows it is a problem and cannot stop it, because the truth, once it gets close enough to the surface, does not wait for strategy. She didn't belong there, he said. The room went still in a way that was different from all the other stillnesses of the morning. Those had been the stillness of people receiving difficult information. This was the stillness of people hearing a thing spoken plainly that they had known for hours but had not yet heard in plain language. It was a different kind of quiet. Reeves said almost gently, "She didn't belong there because of what Calloway looked straight ahead." His chest rose and fell. "Officer Calloway." Adaize's voice from the bench, not raised, not sharp, simply present the way a wall is present. "You will answer the question." He looked at the bench, then. He looked at Adaize Okafor sitting above him in a courtroom that her presence had been running since 8:59 that morning, and something in his face moved through several things in quick succession. The last remnants of defiance, and then the specific and private humiliation of a man confronting what he actually is in front of the people he has spent years deciding do not matter. And then it went still. "Because she was black," he said. The sentence fell into the room, and the room absorbed it without response, without movement, without the release of any of the tension that had been building since morning. If anything, the silence deepened the way water deepens as you move from the shore toward the center. Not allegation, not inference, not pattern analysis. Admission. Reeves waited. He gave the admission the space it deserved. Then, when you grabbed her arm, you had no legal basis for that contact. I was assessing a situation. When you put her on the ground, you had no legal basis for that use of force. I was controlling a... When you left without filing a report, without logging the stop, without activating your camera, that was deliberate. Calloway said nothing. Answer the question, Officer Calloway Adayez said. Yes, he said. It was deliberate. You left her on the ground on the concrete beside her car. She wasn't injured. Reeves said, she has a bruise on her forearm that has been documented by her physician this morning. He did not look at the bench when he said this. He did not need to. She drove home on a dark highway after being physically assaulted by a law enforcement officer who then made no record of the encounter because he believed there would be no consequence. Objection, the defense said without conviction. Withdrawn, Reeves said before Adayez could rule. I'll ask it as a question. Officer Calloway, is it fair to say that what you did to Judge Adayez Okafor at the Edgewater Texaco was not an isolated mistake, but an extension of the exact same pattern that has been described by every witness who has testified in this courtroom over the past 2 days? The defense objected. Adayez overruled it. Calloway looked at her. He looked at her for the first time since retaking the stand, and whatever he had been expecting to see. There, anger he could argue against or pain he could dismiss was not what he found. What he found was a judge. A woman in a robe who had watched him and listened to him and ruled on every piece of his conduct with the same level unsparing attention she had given everything else, and who had not given him a single opening to make this about anything other than what it was. Yes, he said. The word came out stripped of everything, no qualifications, no context, no management. Just the admission itself alone in the room. Reeves said, last question. When you walked across the concrete of that gas station last night toward a black woman alone at the pump, what made you think you could do what you did? Calloway said, nothing. Officer Calloway. He looked at the table. His hands were pressed flat against his thighs. He looked like a man standing at the edge of something he has been walking toward his whole professional life and has only now at the end understood is a cliff. What made you think you could do it? Reeves said again quietly. Not pressing, simply waiting. Calloway's answer when it came without strategy and without cushion, and without any of the performance that had wrapped every other thing he'd said today. It came the way things come when there is nothing left to lose, and the truth is the only thing that hasn't been tried. Because nobody ever stops us, he said. The sentence stayed in the room. It did not echo. It was too quiet for that, but it stayed the way certain sentences stay absorbed into the walls and the record, and the memory of everyone present, not as a dramatic conclusion, but as a diagnosis. An explanation of something that had been operating in plain sight for a very long time, and had simply until now never been asked to account for itself in language this plain. Nathan Reeves stepped back from the witness stand. No further questions, he said. Reeves's closing argument was clean and did not waste a word. He said that what had begun as a hearing into financial exploitation had become, through the course of testimony, something that required a different name. Not misconduct in isolation, but a structure of predatory enforcement that had operated continuously for more than a year, targeting black drivers on a rural corridor, with the confidence of men who had never been stopped and had no reason to believe they would be. He named the component's dispatch logs showing premeditated selection of black drivers before any stop was formally initiated. field notes in the defendant's own handwriting describing cash taken from frightened people, including a 71-year-old woman whose grocery money was taken while her grandson cried in the back seat. A junior officer who had admitted his own participation and described being instructed to keep his camera off in the defendant's own words until we know what kind of people we got. 6 civilian witnesses from different backgrounds, different dates, different amounts who had described the same machine. And the defendant himself, under oath, admitting race as the basis for his conduct on Route 9 and stating in plain language that he had operated without consequence because he expected to continue to do so. That expectation, Reeves said, was not invented by Officer Calloway. It was taught to him by every supervisor who failed to investigate every complaint that was received and filed and forgotten, and every institution that found it easier to absorb the harm than to examine the officer who was causing it. He requested 3 things: immediate referral of all testimony and admitted records to the State Attorney General's office, appropriate federal civil rights authorities, and any oversight body with jurisdiction beyond Oak Ridge County. Full preservation orders on all body camera data, dispatch records, stop reports, personnel files, and communications related to the officers and their chain of command. And notification to appropriate prosecutorial and reviewing courts that all prior cases in which Officer Calloway served as primary or sole testifying officer might require evaluation for compromise. The defense argument was brief and sounded like it knew it was brief. The union lawyer asked for narrow referral language that did not prejudge criminal liability. County counsel said nothing. Adeyeze looked at the record before her. She looked at the room. When she spoke, her voice was steady and exact and carried neither satisfaction nor performance. Only the particular quality of a judge who has weighed everything carefully and arrived at a place she can defend in the specific language of the law. Having reviewed the sworn testimony, admitted exhibits, dispatch records, authenticated summary materials, and direct admissions by the principal officer involved, this court makes the following findings. The evidence presented in these proceedings establishes not an isolated failure of judgment, but a sustained and deliberate pattern of misconduct. Officer Brett Calloway engaged in the racial targeting of black motorists on Route 9, the coercive extraction of cash under color of law, the repeated suppression of documentation designed to make that conduct traceable, and the deliberate disregard of recording requirements intended to protect the public he was sworn to serve. Officer Ryan Foss admitted to participation in and facilitation of the same conduct. This pattern was not speculative. It was supported by multiple independent civilian witnesses' authenticated dispatch records. The defendant's own field notes and internal maintenance history demonstrating that camera failures were not technical but volitional and direct admissions by the principal officer, including an admission made under oath that race was the operative basis for his conduct. This court is not in this proceeding entering a criminal conviction. That authority rests elsewhere and under different standards. This court is, however, both empowered and obligated to act where sworn testimony establishes substantial evidence of civil rights violations, financial crimes committed under color of law, evidence suppression, and racial discrimination embedded deeply into the enforcement practices of a public law enforcement agency. She turned to the clerk. The referral orders were entered. Preservation notices were issued. The notation regarding prior cases dependent on Calloway's testimony was entered into the record. In the second row, Gloria Tate pressed one hand flat against her chest above her heart and held it there. At the defense table, the county attorney sat with his hands clasped on the table and looked at nothing in particular with the expression of a man who has spent the last 2 days watching something he was supposed to prevent and now must explain to people who will not be satisfied by any explanation he has. Adeyeze lifted the gavel. "Court will stand in recess," she said. The gavel came down. The state investigators had been in the building since morning. There were 3 of them, 2 from the Attorney General's office and 1 from a federal civil rights division that had been monitoring the hearing transcript as it arrived in real time at an office 20 miles away, and they moved into the courtroom during the recess with the practiced efficiency of people who had reviewed the record, made their determinations, and were now simply administering the result. The senior investigator was a compact woman in her late 50s with silver at her temples, and the kind of posture that communicated authority without performing it. She held a folder and wore the expression of someone who had spent 30 years doing difficult things in difficult rooms, and had long since stopped finding them dramatic. Calloway was still at the defense table when she entered. The union lawyer was beside him, still talking. He had been talking almost continuously since the gavel came down. One more argument, one more procedural avenue, one more thing he was going to do that was going to change how this ended. But Calloway was no longer listening to any of it. He was watching the investigators cross the room, and what was in his face had moved past defiance and past fear into something quieter and more final than either. The senior investigator stopped in front of the table. Officer Calloway, based on sworn testimony, admitted records and findings entered by this court. This morning, you are formally relieved of active law enforcement function, pending criminal investigation and administrative review. She extended her hand. Your badge. The union lawyer started to speak. She did not look at him. Calloway looked at her hand. He looked at the badge on his chest. He looked around the room at the civilian witnesses seated in the gallery who had not yet left at Sandra Cho, standing near the back wall at Gloria Tate, still seated in the second row, with her handbag held in both hands, and not one of them looked away from him. He reached for the badge. His fingers fumbled once at the clasp, and then it came free, and he held it in his palm for a moment that was perhaps longer than he intended before placing it in the investigator's hand. Your service weapon. He unholstered it and handed it over grip first. The spare magazine followed. The handcuffs from his belt. Each item was placed on the counsel table and tagged, and the small flat sounds they made metal on wood one after another filled the room, the way the sounds of tools being collected fill a room after work is finished. Foss was called next. He stood immediately without hesitation and surrendered his badge and weapon on the first request and said, "Yes, ma'am," to the investigator's instructions before she had finished reading them. The difference between the two men was not subtle. Calloway had understood the badge as something he owned. Foss understood now that he had borrowed it from people he had failed and was giving it back. Adese stood at the side entrance, robed still present. When the investigators signaled, Calloway was escorted toward the door, not in handcuffs, not yet, but under the eyes of Gloria Tate and Marcus Webb and Patrice Hollis and Sandra Cho, all of whom remained in the room, all of whom watched him go. He did not look at them. He tried to look at nothing in particular, which is a difficult thing to accomplish when the room is the size of a courtroom, and there are people in every direction who have decided they are done looking away. The door closed. Adese looked at the room. At the empty defense table, the tagged items, the coffee stain still dark on the wood near where Calloway had sat that morning with his cup and his certainty. At Gloria Tate, who was finally gathering her handbag to stand. The record has done what it was supposed to do, Adese said to no one in particular, and to everyone. What follows now belongs to every office sworn to honor it. By that same evening, the Attorney General's office had opened a formal criminal investigation. Not a review, not a preliminary inquiry. An investigation with assigned prosecutors a case number and a document hold that extended upward through the Oak Ridge County Sheriff's Department chain of command to Lieutenant Hadley, whose name appeared in Sandra Cho's written complaint which had been submitted and ignored 11 months ago. The Federal Civil Rights Division confirmed parallel review before the following morning. Oak Ridge County, which had spent years functioning as a structure that protected its officers from the consequences of their conduct by doing nothing loudly and in the right sequence, suddenly found itself unable to use that structure because the structure was now the subject of the investigation. Lieutenant Hadley was placed on administrative leave within 48 hours. A record supervisor who had overseen the filing system in which 6 civilian complaints had been received, logged and never forwarded to any reviewing authority, announced his retirement at the end of the same week. He had been planning to retire in the spring. He moved the date up significantly. Calloway was suspended without pay and named in multiple criminal inquiries. Foss, through his separate counsel, entered a formal cooperation agreement and began providing a timeline that reached further back than anyone in the command structure had hoped, not far enough to save him from consequence, but far enough to make every institutional story about isolated incidents impossible to maintain. By the end of the first week, 9 cases had been flagged for review cases in which Officer Brett Calloway had been the primary or sole law enforcement witness, cases in which people had pled guilty or been convicted on the strength of his account. 9 names on 9 files, each one belonging to a person who had passed through the Oak Ridge County justice system and come out the other side shaped by an encounter with a man who had been telling the truth about nothing relevant and lying about what mattered. One of those names was a man from Milltown who had spent 14 months on probation for a possession charge he had told his public defender was planted. His attorney filed a motion for relief before the week was out. One was a woman in her late 50s who had lost her car to a civil seizure order after a stop on Route 9 in which Calloway had testified that he observed behavior consistent with drug distribution. No drugs were ever found. The seizure had gone through anyway because that was how the system worked when the officer's word was the only word that counted. Her file was reopened. Nationally, the story took hold in the particular way that stories take hold when they contain both an outrage and a specific human face. Adeyeze's photograph appeared in coverage that moved from local to regional to national outlets over the course of a long weekend, and the journalists who did the better work did not stop at the gas station. They wrote about Gloria Tate and Marcus Webb and Patrice Hollis. They wrote about the 9 flagged cases. They wrote about Sandra Cho's ignored complaint. They wrote about the phrase Brett Calloway had delivered into the record under oath because nobody ever stops us, and they treated it not as a villain's boast, but as a description of a machine, and they asked what it meant that the machine had been running this long before it was stopped. Adeyeze read the coverage the way she read case files, carefully without comment, looking for what was accurate and what was approximate and what mattered and what was noise. Most of it was approximate. The accurate parts were the ones about the other people. The ones about her she read last and thought about least. What she thought about most in those first days was the woman who had not filed a report. The one in the file who had been alone with her children and had decided silence was the safer option. She did not know that woman's name. She hoped when the investigative process moved through the dispatch logs and the command records and all the other places it was now moving that they would find her. That her silence would finally be placed somewhere it could be heard. That first evening after the investigators had left and the courthouse had emptied and Amani had locked the chamber and Bailiff Green had gone home. Adeyeze sat at her kitchen table with the lamp on and a cup of tea she had poured and not drunk. Her brother Leon called from Atlanta at 8:15. He was 55, 3 years older than her, and he had seen the coverage on 2 separate news apps, and then turned the television on and watched for an hour without calling, because he was trying to decide what to say to her and could not figure it out. Finally, he had given up figuring it out and just called. "Are you hurt?" he said. It was the right question, and because it was the right question, she answered it honestly. Yes. He was quiet for a moment, the kind of quiet that contains everything a person feels and cannot fix. She knew the shape of his silence better than most silences she knew. "The arm," he said. "The arm. And some other things." He didn't ask her to enumerate the other things. He knew her well enough to know that she had already enumerated them to herself and would not find it useful to do it again out loud. "Are you going to be okay?" he said instead. "Yes," she said. "Just not tonight." Another pause. Then, because he was Leon, and always found the thing that mattered most, and said it plainly. "You could have told him who you were. Right there at the pump. You could have ended it right there." She looked at the leather card holder on the counter. The judicial ID that had lain on the cracked concrete of the Edgewater Texaco, while Calloway stood 6 inches away from it, not knowing, not bending down, not seeing. She had picked it up after he walked away. She had carried it home. If I'd told him, she said, he would have apologized. He probably would have been frightened enough to behave differently for a while. and he would have learned the wrong lesson, that the only reason to treat someone decently is if they turn out to be powerful enough to hurt you. Leon was quiet for a long time. She could hear him breathing across the 400 miles between Atlanta and her kitchen table. "But you still sat on the ground," he said. "I did." For how long? She thought about it. She had not thought about this specifically, the duration of it, the exact minutes. About 2 minutes. Maybe a little more. That's the part that... He stopped. "I know," she said. "But you stood up." She didn't respond to that. She didn't need to. She reached across the table and put the leather card holder in her bag for the morning. Then she sat with her brother's voice in her ear and the lamp on and the cup of tea going cold beside her, and let the evening be what it was. The following Monday, Adayeze returned to her courtroom for a routine docket bond hearings. 2 sentencing reviews, a scheduling conference in a civil matter. The ordinary architecture of a working week, carrying with it the implication that ordinary work was possible, which was its own kind of statement. Gloria Tate appeared in the hallway outside the courtroom at 8:20 before the docket began. She was not wearing the plum hat today. She wore a cream coat and flat shoes, and carried nothing except a folded piece of paper, and she stood near the door with the particular patience of a woman who has waited for many things and has learned to wait without broadcasting that she is waiting. Adayeze told the bailiff to let her in. The courtroom was empty except for the 2 of them. Gloria walked to the rail and stopped there, not presuming further. She looked at Adayeze for a moment. "I've been thinking all week about what to say," she said. "Most of what comes to mind sounds too small." Adayeze stepped down from the bench. "Most of what matters usually does." Gloria looked around the room, the oak paneling, the bench, the defense table with its faint coffee-colored stain, and then back. "I didn't come to thank you because you were hurt too. I came because you didn't let your hurt make the story smaller. You let it be what it was, which was everyone's story, not just yours." She paused. "That matters." Adayeze felt the words land in the specific place where things land when they are exactly true and have been said by someone who paid the right price to say them. "You told the truth when it was easier not to," she said. That mattered too, before anything else that mattered. Gloria smiled, small, tired reel. "At my age, child, easier is overrated." Adayeze laughed. It was not a long laugh or a loud one, but it was genuine, and the sound of it in the empty courtroom surprised her a little, which surprised her more. Gloria said goodbye and walked to the door, and Adayeze watched her go, and stood for a moment alone in the room after the door had closed, looking at the bench from where ordinary people stood when they came to this place needing something from it. Then she walked back to the bench and got to work. The courtroom holds its stillness long after the people leave. The defense table carries the dark ring where a coffee cup sat for the last time on the morning a man walked in, certain he owned the room. The summary chart is still on the projector, the columns arranged in plain daylight, and the fluorescent light above the defense table buzzes faintly, the same sound as the light above pump number 2 at the Edgewater Texaco on Route 9. The same frequency, the same nervous stutter, and there is no one left in the room to hear it, except the room itself, which has absorbed too much this week to be surprised by anything, including the fact that certain sounds follow you home. On the small counsel table near the rail where the investigators laid each item before tagging it for evidence, there is a faint rectangular outline left behind in the wood, the shape of a badge still readable in the surface. The way all impressions remain longer than the things that made them. Gloria Tate drives home on Route 9 for the first time since that night in March, and she does it in the afternoon, in the full light of a weekday, with her hands easy on the wheel and the radio on low. She passes the Edgewater Texaco without stopping. The flickering light above pump number 2 has finally been repaired, and it burns steady now, which is either nothing or something, depending on how long you've been watching it flicker. On the passenger seat beside her is a printed copy of the court's findings because she wanted it close to her body for this first drive, and when she reaches the county line without incident, she doesn't celebrate. She just keeps driving. Behind her, across 9 counties, 9 case files are moving through 9 different offices, each one carrying a name at the top that belongs to a person who once paid a price they were never supposed to have to pay, and who is only now beginning to learn that someone finally wrote it down. Adeyeze puts on her robe the next morning the way she has always put it on, alone in the small room beside the courtroom without ceremony, the fabric settling around her shoulders, the way familiar things settle. The bruise on her forearm has faded to yellow at the edges, still tender when she reaches too far, healing the way things heal that have been struck by something real. She picks up the leather card holder from the corner of her desk, the one that lay on the concrete at the Edgewater Texaco, while a man who believed she was no one stood 6 inches away, not knowing, not bending down, not seeing, and she holds it for a moment, turning it over once in her hand. She does not keep it as a trophy or a reminder of what was done to her. She keeps it because justice was never supposed to depend on who you turned out to be, and that night it didn't. And that is the thing she wants to remember, not the ground, not the cold, not the 2 minutes she stayed there before she stood, but the fact that it will matter for the women on that road who do not have her robe, and that the record she built in that courtroom belongs to them more than it will ever belong to her. She sets the card holder on the corner of her desk where she will see it every morning. She walks to the bench. Below her, people are already in their seats. People with cases and fears and ordinary lives that deserve the full protection of a system still imperfect enough to require constant watching and still capable enough to sometimes get it right. The bailiff calls the court to order. She takes her seat. She opens the first file. The gavel is already in her hand. If this story moved you, if you saw in it something of the road you've traveled, or the silence you've carried, or the moment you finally stood up, share it with someone who needs to hear it. Subscribe to our channel. There are more stories waiting, and they belong to all of us.